criminal trial process is an important aspect of justice and upholding the law in Canada. A criminal trial occurs when one or more people break or are thought to have broken a law or laws. The laws are outlined in the Criminal Code of Canada, and the trial is meant to determine the innocence or guilt of the individual charged with an offense. Many people are involved to ensure that this individual has a fair trial, and there is a specific process that courts follow to ensure that every criminal trial is conducted in the same manner. Courtrooms may be set up slightly differently, particularly today with online trials, but there are several key rules at each criminal trial. The person in charge of the courtroom is the judge. The judge is impartial so that their decision may be fair and only based on the evidence presented, the existing Canadian laws, and the precedents set by previous cases of a similar nature. Unless either party chooses to appeal to a higher court, the judge's decision is final and is meant to resolve the issue between two parties. In a criminal trial, the two parties are the accused and the Crown. Each is normally represented by a lawyer, the defense lawyer and the prosecutor, respectively. The accused is the individual who is charged with committing an offense, and the defense lawyer represents this individual. The defense lawyer ensures that the accused's rights are protected during the criminal trial. The defense tries to create a reasonable doubt regarding the accused's charge, whilst the prosecutor, the Crown lawyer, tries to prove beyond a reasonable doubt that the accused committed the offense that they were charged with. Even though the offense has usually been committed against a person, the victim is not the one defending her or himself, because the accused, by committing the offense against the person, broke the law and therefore committed the offense against the Crown. Beyond a reasonable doubt is an important phrase in Canadian criminal trials which refers to how the prosecutor, who may also be referred to as the Crown, must have such a strong case that there is no question in the judge or jury's mind that the accused committed the crime that they were charged with. The Crown has the burden of proof, meaning that they have to prove the accused's guilt, rather than the accused having to prove their innocence. If the prosecutor cannot convince the judge or jury that the accused committed the offense, the charges may be dropped. Both the defense and the prosecutor may call witnesses or victims of the offense to testify and provide evidence to support either side's case. The jury, which is made up of 12 randomly selected Canadian adults, is present at some criminal trials for indictable offenses. Indictable offenses are more serious crimes such as murder or theft over $5,000, in contrast to summary offenses which are less serious crimes. The jury's job is to decide, based on the facts and evidence, whether a person is guilty or not guilty of the offense that they were charged with. In a jury trial, a judge directs the jury, interprets the law, and sentences the accused, but the judge does not decide whether the accused is guilty or not. These are the main roles in a criminal trial. However, there are a couple of others that are worth noting. A court clerk helps the judge, a court reporter records the proceedings, and a court officer is meant to protect the people present. The investigating officer helps the prosecutor, as this person was involved in the investigation of the case. In situations where the witness or accused would prefer to speak in a different language, a court interpreter will be present to translate. Sometimes a support person will help the witnesses. Finally, a public gallery is an area where the public may watch the proceedings and reporters may attend and share information with the public about the case. Now, how does a trial actually work? In every criminal trial, there are several steps, and the first is to call the case. Then, the trial begins. A formal arraignment, which is the reading of the accused charges, occurs first. Sometimes an exclusion order is made. This order ensures that all witnesses leave the room so that their information and perspective is not impacted by other witnesses' testimonies. The Crown, represented by the prosecutor, always presents their case first. This is followed by the accused or their lawyer cross-examining the witnesses that the Crown brought to the trial. There are several important aspects of the crime that the Crown must prove. First, it must be clear that the accused actually committed the crime, or had the actus reus. Second, the Crown must prove that the accused intended to commit the crime, which is known as the mens rea. Finally, it must be clear that all aspects of the crime itself occurred. After the prosecutor has presented their case, it is the accused's turn to present their case. However, it is not necessary for the defense to call evidence. If the accused does choose to call witnesses, the prosecutor will cross-examine them. Since both the Crown and the defense use evidence to support their case, let's discuss that briefly. Evidence is only allowed at a trial if it was collected in accordance with the law and if it is relevant to the case. There are four main types of evidence. They are physical evidence, testimonial evidence, documentary evidence, and demonstrative evidence. Physical evidence, also known as real evidence, includes DNA, fingerprints, and weapons. Testimonial evidence is shared by someone who witnessed the crime or someone who analyzed the outcome of the crime, such as a coroner. Evidence such as a diary entry, newspaper article, or film recording is considered documentary evidence. Finally, demonstrative evidence consists of evidence that is used to illustrate a witness's perspective. This could be a map of the area in which the crime occurred or a diagram showing the victim's injuries. Once all the witnesses have testified, legal submissions are made. These submissions explain how the laws relate to the case and they explain the outcomes of previous similar cases. Before the judge or jury makes a decision, both sides sum up their cases. If it is a jury trial, the jury is the trier of fact, and the jury will be sequestered so that they can deliberate and decide upon the accused's guilt or non guilt. In the case that there is no jury, the judge is the lone trier of fact. If the accused is convicted or declared guilty, the accused will receive their sentence. The judge will take several things into account when deciding upon a sentence, including the character of the accused and the impact of the harm on the victims of the crime. If an individual is acquitted, they are free to go and the trial ends.